No punches. I like to be
Study for sales.
Okay, so welcome everybody. We have a very, very special treat today. I'm biased, I know. I've been harping to my students who are here who know this. We're going to be discussing the hottest corporate law issues and with the most amazing speaker. Thank you so much. Professor Eric Talley from Columbia Law School is here to discuss what's going on with Delaware corporate law. All of us are asking. We're going to wait for you to see a little bit about the empirics. I just want to tell you a few words about Professor Talley. He's an expert on the intersection of corporate law, governance, and finance. He teaches in the areas of mergers and acquisitions, quantitative methods, yes, machine learning. He's got some cool projects about that, contracts and commercial law, alternative investments, game theory, and economic analysis of the law. He's a co-director of the Ira Milstein Center for Global Markets and a corporate ownership at Columbia. And he's elected member of the American Academy of Arts and Sciences, a research member of the ECGI, the European Corporate Governance Institute, an executive member of the Columbia University Data Science Institute, and serves as a director of the boards of the Society of Empirical Legal Studies and the American Law and Economics Association. I'll just say one more thing. The reception afterwards is going to be here in the lower level and not in Ben's place. Thank you so much for doing this. So the stage is yours.
Thanks a lot. Appreciate you all coming out today. This is my first time to Case Western, so it's terrific, and I like it. I'm enjoying it. So thank you all for showing up, even those of you who are getting course credit for being here. So how many of you have been keeping track of what's been going on literally like for the last week in Delaware? All right. It's kind of nuts, and I want to give you a little bit of a tour of how I've experienced it over the last week. When Anat asked me to come do a talk here, I was going to give you some boring paper I was working on, and we could roll this into a second hour, and I'm happy to give that boring paper. But the fact of the matter is, this is in some ways kind of an interesting watershed moment, or it may prove to be that way. It's still early days, so we don't know for sure. And what it ends up effectively doing is it involves all the magic ingredients of a great pot boiler in corporate law, right? It involves Delaware, the structure of its code, the structure of its precedents, the idea of regulatory competition, which is super cool as well, and I can say a little bit about that today. And of course, a necessary ingredient in any conversation about corporate law is Elon Musk, and it also involves Elon Musk. So we have kind of all these things going on at the same time. And I'll tell you about the genesis, about how I got kind of pulled or sucked or hoovered into this web. It was really only about 8 or 9 days ago. I got a phone call from some attorneys who were like, did you know that there's like a pretty big pending legislative reform that is that has not gone through the regular channels, which I'll talk about momentarily, that is being introduced in the Delaware Assembly that it looks really large. And I said, no, I haven't seen it. Can you give me a copy? No, we haven't seen a copy. We've just been told about it, and it's just going to happen on Monday. So I tried to figure out as much as I could what was going on. As soon as it dropped on Monday, I spent a lot of time reading it, and then I and a couple co-authors who have been co-authors in other troublemaking things with me dropped a blog post last Tuesday, I guess a week ago today, and a lot of fur has been flying. Our fur has only been part of the fur in this maelstrom. So I'll tell you a little bit about what that reform was, and why it's kind of it poses interesting. I don't want to be too dramatic. Sometimes you say it poses existential questions for Delaware, but quite frankly, I just want to pull back a little bit from a collective swooning, fainting spell that we always have, and we're prone to having these days. And try to get a little bit of a distance. I think there are some problems with this, but I also want to give it its fair shake. So here's what I'm going to hope to get to through in the next 40 minutes. I have, by pre-arrangement, given at least the faculty, and I'll give the students as well, my dispensation to just interrupt me if there's something that, I'll assume it's my job to shut things down if I need to get further on in my presentation. So here's where I want to try to get through, and I want to actually set the stage not with the statute, but to talk about a topic that is actually pretty fundamental in a lot of corporate law. You also see it in environmental law, you see it in criminal law and other areas as well, which has to do with the idea of regulatory competition. And so I want to talk a little bit about that, go through what this Senate Bill 21 or SB 21 is proposing to do. And if those of you who have taken corporate law, you'll kind of immediately get a sense of the potential magnitude for this. Why the drafters of SB 21 claim that this is necessary, and is that actually convincing if you look at the data? What do I like about it? What do I dislike about it? As I sit here today, and it's again early days. And then finally, particularly for the students in the room, but also we'll see from the faculty in the room, like if this is going to happen, what do you do to get ramped up for this change? Because it does have the potential to be a relatively large change. So let's start with this regulatory competition, the so-called race to the top, race to the bottom sort of debate that you see in a lot of areas involving state by state or interstate competition. In this case, to try to get companies to charter in your state. Now, why would you want to get companies to charter in your state? You can get some money, right? And this is a business law colloquium. That is, good guess that that's going to be the answer to at least half the questions. And in fact, Delaware does charge a franchise fee that is based on, how much are you going to, what are your shares, and in some ways, what is your size? And so we'll talk a little bit about that. And so the idea is that you may want to structure your corporate law, or environmental law, or criminal law, or tort law, or whatever, so as to attract decision makers who want to, are trying to figure out what's the best place for me to incorporate or locate my plant. In this case, it's incorporation, so you don't have to even relocate your plant at all. And what's that going to look like? Now, this is not a new debate. I worked like crazy to try to get Talley to generate a single image that would deal with the various dimensions of this debate. And I'm just going to tell you this, it was crappy, and then it just like shut me down. So, but the idea is that there are actually kind of three parts to this debate. And it goes back probably to the early 70s, where I guess it was like William Carey and Ralph Winter were writing articles that basically made put forward sort of competing propositions. I think Judge Winter was responsible for the idea of saying, hey, look, these companies, they're actually going to want to pick regulatory environments that maximize their value, because they got to go out and get investors to invest in them, and investors are going to discount a really crappy corporate governance system or legal regime, and therefore, as a way of kind of generating investment, they're going to try to find the best corporate law venue they can. All right, and because of that, when these states get into a race, they're like racing to the top of the mountain. They're racing to the best. And I'm going to come back and circle back and interrogate, what do we even mean by the best, particularly in a world where there are heterogeneous organizations. So that was one view, like that you should expect that if someone wins this race, if they won it with quality, right? Because they just maximize value. But of course, if there's a race to the top argument, there has to be a race to the bottom argument. And this was articulated by William Carey. He said, look, who are the decision makers who decide to do this, right? Yeah, it's the boards and CEOs, and yeah, they do want to attract investments, and I'm sure that matters to them, but if you sit that next to, do I avoid personal liability by operating in a given state, possibly in some cases that second consideration is going to have a decisive weight. And so under this view, states actually compete with each other, not to create value, but to create kind of a layer of insulation around managers, CEOs, and directors. And the state that wins the race has just like come up with the thickest layer of insulation. All right, so that's sort of the race to the bottom, and that is not necessarily going to be something that's consistent with stockholder or investor interests. All right, and that was a debate for about 20 years, and at some point people kind of looked around and said, this isn't even a race, right? Since probably the middle of the 20th century, Delaware has basically just owned this race. They're essentially sitting in the lounge chair with a drink and a monopoly board saying, we just have a gigantic market share. We don't, whether you race to the top, what race to the bottom, we basically have market power, and that market power is almost self-feeding, right? When you think about it, I was trying to total this up in my own mind, but I've now been teaching corporate law for almost 30 years. I think that translates. I know it's horrifying, isn't it? Particularly for the child actors in the room. So it is probably the case. You check me on this, Charlie, if you think I'm wrong. But I think I probably pumped out about 12,000 practicing corporate lawyers, and the only thing I've taught them is Delaware law, right? Because it was so dominant, and so on some level, when we replenish the set of lawyers out there, we're doing so with people that walk and talk and sleep and sneeze Delaware corporate law, and that has all kinds of network effects. Investment banks kind of have analysts that talk about how's a Delaware court going to deal with this fairness opinion and so forth. So Delaware essentially has owned this market for a long time, and that's not much of a race. Here's just some stats on the number of business entities. Corporations are sitting at around 400,000 corporations in Delaware. LLCs are even larger than that. If you look at the total number of business entities, it's over $2 million. 2 million entities. That not only exceeds the population of the state of Delaware, probably by about double. I was told by Chancellor McCormick this also exceeds the number of chickens in Delaware, but I have come to doubt that statistic, but it's at least kind of a point that you could have an argument about. About 2/3 of publicly traded companies are incorporated in Delaware, even at the top end, middle, even bottom. The other states, you look at any one of them, they're going to be down in the lower single digits in terms of their share of public companies. About 80% of IPOs to this day are still Delaware IPOs. That is the moment where you're having to raise money, right? So one could make an argument that that's where you're really going to try to cash in good law, or at least familiar law. And these market figures have been relatively stable over the last couple of decades. I will give you a few stats in the last 3 or 4 years based on the current dilemma. So how does Delaware get so dominant? Well, sometimes you will hear people refer to something called the Delaware Way. And what that is essentially shorthand for a summary of the ecosystem in which Delaware law has developed and currently operates. And I'll put it in a somewhat shallow-looking smart art diagram here. But so one of the reasons why Delaware has been thought to be dominant is that it's got a special court. Unlike most states, Delaware never merged its law and equity courts, and instead it repurposed its courts of equity effectively to be specialist business courts. In order to make it on the court of equity, not only do you have to be a Delaware resident, but you have to have background and expertise in business and be sophisticated about it. And they take that sophistication and are given a fair amount of discretion to craft equitable outcomes. And that is clearly an important ingredient. Another one is that there are a lot of precedents in Delaware law, right? And this is in part of a network effect, right? A lot of companies incorporate there. They sometimes get into disagreements. Those disagreements sometimes boil into a written legal opinion. And it's almost like you've got a scatter plot of a whole bunch of precedents out there that you can kind of fit the line to with some confidence, because there are a lot of examples out there. All right. Third, and there are so many, in fact, that other states, even Nevada, will cite to Delaware cases, right, for various principles that just haven't been explored in that state's law. There's also a statute, Delaware General Corporate Law, that is thought to be flexible and is committed to so-called contractarianism. Like, here's a set of rules, but if you do it the right way, we're going to give you the ability to adapt your governance system in a way that's not the same way that these rules are laid down. And for the most part, Delaware has an enabling statute. Not that there are some immutable rules, but a lot of them are enabling. A lot of practitioners, these are the people like future yous out there, right? That kind of they walk and talk and sleep and sneeze corporate law, and they all have a secret decoder ring, and they can secret handshake, and they know how to talk to each other in Delaware law speak, and that is very, very helpful. And then finally, capital markets, right? Investors are saying, hey, we kind of get how these various pieces are interacting. That gives us some confidence that this is going to be a place where we can invest our money and not have it, essentially held hostage. Just kind of weird stuff. Yeah, there's risk, but it's risk that we understand. It's known unknowns rather than unknown unknowns. Right? So you combine all these things together, and they sort of all collapse into the Delaware way. And I'm going to come back to this very business school looking smart art figure in a second. Here's a picture of the Delaware Chancery Court. It has expanded over the years because there have been an increasing number of cases that have been brought, but the Chancery Court's job, right, they get this statutory law from the Delaware General Corporate Law, but they also are a court of equity. And as it turns out, this is something I guess I had been familiar with this, but I didn't remember it until about a week ago. It turns out that some of the Delaware Chancery Court's powers are constitutionally guaranteed as a court of equity. And that's going to possibly prove important for the existing situation. All right, and I'll talk a little bit about that. I don't know if there are any state constitutional law people here. So you can't call me on my prevarication. So anyway, they've got basically this common law equitable task. They're trying to combine that, make sense of the Delaware General Corporate Law through their own expertise, and you effectively end up having a large body of aggregated opinions. And it's kind of notable, because one of the things, I'm not citing very many cases here, but there's an oldie called Schnell versus Chris-Craft, which is basically a statement that says, it's one thing to comply with the law, and it's another thing to do something that is equitable. All right, so Schnell, Chris-Craft, basically the trope that comes out of it is, actions of fiduciaries are twice tested for their compliance with Delaware law and their compliance with fiduciary principles and equity. All right, and that's going to be a theme I'll come back to in a bit. All right, so that's sort of a little bit of background of whatever race that you might think is going on, as well as Delaware's dominance and why people think it has become dominant in that race. Let's talk about these statutes. Now, there are essentially two major statutes that this kind of springing proposal proposes to change. There's going to be some other ones this year that are going through more conventional approaches, but these are the ones that are the kind of the big surprises that have been making all the news. The first one, which clearly is the biggest of the two, proposes to change Section 144 of the Delaware Code. Now, Section 144 is a very central code. You probably, if you teach corporate law, you spend a lot of time going over its architecture. It's kind of an odd section because it really was originally drafted to just deal with whether, a conflict of interest involving a director or an officer could cause a transaction or an action to be void, all right? And it basically makes a correction that just because you've got a conflict of interest doesn't mean that it's void if it's appropriately approved by disinterested directors or appropriately approved by stockholders, or if you can prove that it's fair to the corporation. All right. Notwithstanding the fact that the way that it's worded is fairly limited, it became the template for pretty much all fiduciary sort of practices in Delaware law. Right. That
Does this apply to non-stock corporations as well as stock corporations, so non-stock corporations and nonprofits as well as stock corporations?
So nonprofits it absolutely applies to, because if you're a nonprofit in Delaware, guess what code you're using? Exactly the same.
Okay.
LLC is a little bit more complicated. The LLC statute has something that's not unlike this. It's a little bit more updated, but it's so contractual with LLCs that you'll just get a lot of tables. All right. So what this proposal does is that it first of all says, hey, this isn't just about voidability. This is about fiduciary duties, and so we're going to upgrade it to be about fiduciary duties. And while we're at it, we're going to talk about a bunch of other things too. I put some things in red. Probably the first one is that instead of just a question of voidability, it says, oh, there will be a broad bar if you have done one of these, cleansing sorts of maneuvers or have proven it fair. There's a broad bar to equitable relief, award of damages, or other sanction. Courts are not allowed to grant equitable relief if you've gone through the hoops that are in this statute. There are some other things that there are a lot in here, and I don't have enough time to cover all of them.
So Ed, I was talking to Ed Rock about this, and he says this is mirroring the MBCA. How do you feel like, we've always, the way I teach it, we've got the MBCA, we've got Delaware, and now, what they're
Yeah.
trying to mirror MBCA, that's a big deal.
Great. So for the non-jargon speakers in the crowd, the MBCA stands for the Model Business Corporations Act. It is a model act that has been adopted by probably about 24 states, maybe as high as 30. I don't know exactly what the count is in some form. And Delaware kind of took pride in the fact that they differentiated themselves from the MBCA. These are proposals that, at least by some accountings, would pull things more consistent with the MBCA. And that is kind of an interesting move. And it's an interesting move from a regulatory competition perspective as well, which I'll talk about momentarily. A couple other things that are probably worth noting. One of the ways that you can cleanse a conflict of interest is to get a committee of disinterested directors to vote to say that's okay. In Delaware, at least as of today, that committee has to be 100% independent and disinterested, and then they would vote by a majority. This would basically downgrade that to say it has to be a majority disinterested, and then they have to vote by a majority. But I'm not judging. I'm just giving a factual description here. So that's kind of an interesting thing. It reduces a big one here, because there's a huge case about a year and a half ago that involved a controller, right? A stockholder that actually had control of the company that came up with was a spin-off and didn't. And it turns out that the way that the law is developed with controllers is if you want to get protection, you want to get a hall pass on a conflicted transaction, you actually have to get both an independent committee vote and disinterested stockholder vote. And they sort of challenge it, say that's not true generally, that's only true for certain types of so-called squeeze-out transactions. Went all the way to the Delaware Supreme Court. I wrote a brief on it saying that's not true, and the Delaware Supreme Court said, yeah, it's not true, right? That in fact this is in fact a holistic law applying to controllers. That controllers, the dangers are sufficiently high that we're going to make you do both the belt and the suspenders of cleansing if you want to essentially be able to walk. The last thing that there's a whole bunch of other ones that we talk about them during Q&A. The last one that ends up playing a pretty big role, I think, hasn't been heavily noticed, is there is no provision in these new changes, and there are a lot of them here, that says, except as otherwise provided for in the Certificate of Incorporation or the bylaws. All right, so this is going to be an immutable rule. Whether you wanted this or not, if it goes through, this is effectively going to be the thing that covers you. And this, Section 144 has long been thought to be one of the more immutable parts of Delaware law. So Delaware is making a big change here, or at least what a lot of people, including myself, think is a big change, and they're doing it on an immutable basis, right? You incorporate it in Delaware, thinking you're going to get the old system. Well, guess what? New sheriff in town, and here's the system that you're going to get. Maybe it's better, right? But it is going to be different. The other one is an amendment to Section 220. And Section 220 deals with a very long-standing common law right that stockholders have to inspect the books and records, including shareholder lists, but also like financial records and governance documents and so forth. For years and years and years, when stockholders would come in with a complaint, and then they hadn't spelled it out much with specificity, courts would boot them out and say, look, you gotta plead with particularity to make this complaint, and guess what? There's a mechanism to do it. It's Section 220. And so that's gotten kind of, on some level, heavily developed over the years. It's a very, very active area of jurisprudence, of litigation in Delaware right now. I think even a plaintiff's attorney says, yeah, 220 actions are definitely going at a clip that are relatively high. It's kind of the only form of pre-lawsuit discovery that a stockholder has. And, activists use it, potential plaintiffs use it, ordinary board pensioners use it as well, right? So there are all kinds of ways to do it. And the threshold is generally pretty low. So what this proposal does is it effectively narrows the types of things that you can ask for in a books and records request. And it limits you to a 3-year look-back period, nothing more than 3 years, which is possibly a little bit problematic for things like Caremark claims or things that aggregate over time. And it doesn't appear to allow like informal, like if there's a text message thread between the board members that over the last couple of years, would be something that you would generally, if they do their discussion over text messages, then you could get those. That seems to be excluded. Yeah.
I think that's gonna just make it, who's gonna use it? I mean, why would I use it? Because, corporate lawyers draft the minutes.
Yeah.
So, and how am I gonna see Elon Musk text to his buddies, from now on? No, I'm serious. I mean, it's gonna chill litigation and also using 220.
It's almost like that might have been part of the. And by the way, students out there, I'm hoping that your excellent professors who have taught you business associations have spent a little bit of time on how to craft a seemingly informative but substantively quite boring set of minutes that don't have all kinds of threads. Dean Rose.
Eric, can I go back to your last slide? What's interesting about this, and I appreciate you raising that issue, most of the time when Delaware has some kind of toggle where you can allow an action that will sort of add to the insulation that directors might receive, you're thinking like 122.17 to allow certain kind of conflict transactions, or 102b7. It's kind of interesting to me that they could have done that with this, right? They could have toggled it, but did you get a sense that they even considered that? So instead of doing this, just say, we'll let you toggle to that.
Yeah.
Like we do with 122.17 or 102b7, rather than just make it sort of a mandatory, hey, everybody gets this.
Yeah, so part of your question is, what sense do you get about what the drafters were thinking? We don't even know who the drafters were, per se. We do know that Elon Musk's law firm was coordinating the draft.
I heard some of the rumors.
And I have heard some rumors as well, but this is a public lecture. All right, and so that is kind of an interesting aspect of this. It immediately struck me as a potential, like, for a state that celebrates its contractarian nature, why would you flip it? Now, historically, Paul, as you know, 144 was kind of an immutable sort of thing, but over time, 122.17, 122.18 have actually kind of said, well, you can write a contract to get around it, but this is not what this proposed section is doing, all right? And then it may just be that no one thought about it, right, because of the history of 144. Yeah.
I just want to understand this on the previous slide about does not appear to permit informal board communications. What's that saying is it doesn't appear to permit access to informal board communications.
Correct.
Because, I mean, I think in this day and age, boards operate via informal communication at least as much as they operate by meeting.
Yeah.
Yeah, that's why we want that. If I was a litigator, that's the only thing I care about.
Right, so all I want is the text messages. I don't care about the meeting
Correct.
minutes.
So here's how I understand, and there's still, this is my attempt to read in a straight up way. My sense is this: if you've got a board or committee that just doesn't keep minutes, you can probably still try to get the text messages. But if they have a practice of keeping minutes, even if they're kind of inconsistent about so doing, you might actually be shut out of getting any informal board.
So your advice to your clients is keep minutes.
Keep minutes. There's the advice that I tell my students to give their clients all the time. There's all kinds of, all the hours on the minutes will save you months, right? And so it's worth thinking about doing that. All right. Okay, so what is the significance of these reforms? And, I threw up a whole bunch of bullet points, but quite frankly, we're all smart people. You can throw up bullet points till the cows come home and ask, is this more form than substance? Well, one thing that I ended up doing, I've been on LinkedIn crowdsourcing crap like crazy over the last week, and one thing I sort of asked is, here's my sense of the precedents that would be overturned in whole or in part, at least likely overturned, if these things go in and are made effective as is. And then I got suggestions from other people. What I came up with, 144, there are a lot of them. Section 220, the art. Now, these are only Delaware Supreme Court opinions, all right? And I think I'm up to about 35 or 36. Assume, I think, safely that there's probably 2.5 or 3 Chancery Court opinions for every one of these things. And so this is a lot, right? Delaware Supreme Court doesn't just do corporate law cases, right? They spread their act around quite a bit. And so so this is a fairly, and you will see cases that you know quite well and probably studied in your business associations class here. And that doesn't mean the entirety of the opinion has been overturned, but at least some material component of the opinion would be overturned. So this would have an effect on the stock of valid precedents that we can kind of refer to when we're trying to make predictions on behalf of clients or predictions on how a case is going to come out. All right, it sounds a little bit like, kind of a Tums moment or a sodium bicarb moment. But I'll come back to, is that also kind of an opportunity, particularly for the shorter in the tooth people here in the room. All right. So why did the drafters say we got to do this, and we got to do this now? The thing that's kind of interesting, they didn't even take this through the usual approach of having what's known as the Corporate Law Council, which is a group of practicing members of the bar, both on plaintiff and defendant side, that is usually the formulator of the first proposal of corporate law reforms. And in fact, they're doing that in a different set of sections. They were already going about doing it, but this kind of end ran around everyone, and as far as I know, the council was not read in on this as these things were being drafted, and purportedly that's because it's critical that we get this done now. There's an emergency that we need to take care of, and that emergency, I just don't want to ignore the Tesla elephant in the. That's probably not going to have legs, but. Last night it seemed like it seemed like a good idea last night.
Yeah, right.
All right, and this is the now year-old opinion, more than a year-old opinion involving Elon Musk's compensation package, and invalidating it, determining that Mr. Musk was a controller, and as a controller he also influenced the committee that approved his compensation. And then they didn't disclose all that fact to the stockholders, so the stockholder vote wasn't informed either, and therefore he and Tesla would have the burden of demonstrating the entire fairness of the transaction of the compensation scheme, the largest compensation scheme in the history of humankind. And that's a hard lift if you're having to bear the burden. And so the case, and by the way, we can talk about Tesla later on. I suspect many of you are sick to death of talking about it. There are appealable points, right? There are points where, I could make a pretty strong argument that this should get reversed on X, Y. I can think of about 3 or 4, but it's true of every opinion, right? And I think that was true of this one as well. Within hours, we have a tweet: never incorporate your company in Delaware. In the last month, any lawyer recommending incorporation in Delaware is committing malpractice.
I saw that. That was wow.
And so, Elon turns out to be a relatively influential guy. And the new governor of Delaware, also was mindful of this and basically said, we're going to have to do something so that we don't have a target on our back. And within a month of this statement come out, we have this kind of side door set of proposals. All right. So that is something, an elephant in the room. I want to note, however, that there's a legitimate argument that had all these proposals been passed and in place when this compensation package was awarded, you could make an argument that it would not change the outcome of the case. All right, he wouldn't be a controller under the new proposals by rule, but the domination of the board and the inaccurate information of the stockholders, you could still make that argument that they would have been the same. So it's kind of an interesting point, and a lot of people say, no, it's not just about Mr. Musk, it's about Delaware exit or Dexit. All right, that companies are just rushing the exits in Delaware and are essentially fleeing. Leaving Delaware holding an empty bag, and we need to do something quickly to staunch the bleeding. All right, so let's talk a little bit about the bleeding. Here's from the last 4 years, all of the more than $1 billion companies that have either incorporated out of Delaware or into Delaware. This doesn't count people, like Meadows as we're studying it, and it doesn't count companies like Fidelity Financial or Mara, who tried to do it, and they didn't get the vote. All right, so it doesn't count them. And if you do sort of a head count, you'll see that it looks like it lines up pretty evenly, right? About half of them are leaving, half of them are arriving. All right. The biggest one that left is clearly Tesla, and clearly some of the biggest ones on the list are leaving Delaware. right? Now that could matter, right? If you're thinking it matters for tax revenues, it doesn't, all right? Franchise tax fees are capped at $250,000 even for the biggest companies. So every single one of these companies was probably paying $250,000 a year in franchise tax for their to the state of Delaware. And losing a $100 billion company is roughly the same as losing a $500 million company for those purposes. It kind of it is a quantitative measure whether you hit that top level of $750 or $250,000. All right. What about over time? All right. So this is some data that my co-author Jens Frankenreiter and I put together. That basically it's a little complicated. But we've sliced the last 4 years into 6-month intervals and asked how much reincorporation is going on from some U.S. state into Delaware, how much reincorporation is going from somewhere out of the country into Delaware, and then the opposite questions: reincorporation from Delaware to some other state, reincorporation from Delaware to some other national jurisdiction, and also like we're keeping track of, you go from Montana to South Dakota. How many companies are doing that as well? And what you can see, like the biggest trend is a declining trend, but it's a declining trend of reincorporation from outside the U.S. into Delaware. That's the if there's any trend here, that's the trend that that seems to be going on, but it's not necessarily fleeing Delaware. I think in the last 6 months, there's been a little uptick in fleeing Delaware. That's the red bar. But it's not that different from some of the red bars that we have seen in previous semi-annual accountings. Yeah.
I'm curious about, do you find here leaving to outside the U.S.? Leaving.
Yeah, so we have that reincorporation from Delaware
to other. Okay, that's
to
the
other.
that's the red.
Red is Delaware to other U.S. state.
Okay, I can't see that well.
Yeah. I don't actually. We probably could track that as a sixth category. We just didn't do that. So people, I mean, this was a big thing in 2015 where everyone was
That's why I'm
reincorporating
asking.
to Ireland or Malta
Exactly,
for
that's
tax
why I'm
reasons.
asking.
I'm going to come back to that actually at the end if I get to the end. All right. What about new incorporations, right? What about, not reincorporations, but brand new companies set up, right? There are a lot of tech bros in Silicon Valley. They're setting up their companies. Have we seen a shift away from Delaware in those incorporations? The answer is generally not. Delaware has been getting about 90% of them. Maybe a very, very small drop off in 2024, but that's kind of rounding error when it comes right down to it. So there still has been pretty big stability, at least in the numbers. The best numbers and most current numbers we have looking retrospectively. Now that doesn't mean that there can't be trouble on the horizon, but just realize it's like you're going to base that on an empirical observation. It's not really a strong one. Number of franchise tax filers in Delaware has been growing repeatedly. There was a slight fall off in tax revenue last year, but that probably has a lot more to do with companies basically just going out of business rather than reincorporating. All right, because remember, there's this kind of flat ceiling to the amount that large companies are going to pay in Delaware. So where does that kind of leave us? Is this a real thing? Well, look, as measured by the amount of attention it's gotten in the press, absolutely it's a real thing, right? There is a lot of drama that is going on right now in the press, and that's something you should contend with, right? The optics matter. As measured by actual data, however, I'm not seeing a lot, all right? And so if you're saying, oh, there's all kinds of evidence that Delaware is losing its edge, empirically, that evidence is pretty scant, right? It's a couple big companies in which controllers play really, really big roles and also have a very broad social media presence that seem to be driving that empirical case, as it were. But that doesn't mean that Delaware doesn't have a PR problem, right? And attending to that, I think, is probably important. And so even though empirically Dexit is more myth than reality, it still is a thing that I think you would want to be mindful of. All right? So what do I like about these amendments? What do I not like? Everyone's going to be different on them. And let me start with some things that I think, this isn't a terrible thing to see. Like, I will say, Paul, going back to your statement on Section 144, it is like a museum piece when you teach it, right? And then you have to like say, like there's a part that says, oh, you get shareholder votes to cleanse a transaction, but it doesn't say it has to be disinterested stockholder votes, right? And you know, a case that came out later on called Flagler versus Lawrence sort of said, yeah, the assembly just kind of screwed up on that. We'll just use the twice tested, you know, approach to sort of say it's got to be disinterested stockholders. Tethering everything on voidability was very much a debate that was going on in 1967. We've kind of moved beyond that. So I could see some attempt to update it to make it conform a little bit more to evolving fiduciary standards. Having some order in the 220 process, certainly all defense side litigators would say this, and probably at least some portion of plaintiff side litigators would say it as well. So I could see like trying to shore up the 220 process a little bit. There's also kind of a move that was made in the new 220 to sort of say we may have created a problem last year with a section 122.18, which Dean Rose talked about, that dealt with stockholder agreements that you might never find out about if they're not deemed material or it's not a publicly traded company. We're going to make sure that everyone knows that you can get one of those in a 220 action. So there are things to actually like. I would have been, you know, having them fall into a debate inside the council or at a conference or something like that seems to make a lot of sense. Things that I don't like, though, I will confess, kind of, or at least kind of worry me, outnumber the things that I like. So I've got some on process and some on substance. On process, this is a pretty hastily written document. As far as I can tell, drafting was going up all the way through the 11th hour or maybe 11:59, and no one knew exactly what provisions were going to be in it. Its definition of a controller is an example. It says a controller is someone that owns that controls more than 50% of the vote, or alternatively, someone that controls more than 33% of the vote. I'm not really sure that the 50% thing means much, right? And so there are aspects of it that seem, you know, and there's, yeah, that's what the legislative process is for, but it does sort of suggest that, that it did not benefit from the kind of scrutiny and vetting that it might get had it gone through the Delaware Council, which is pretty much how most of the rest of these things work. I think there's a little bit of what the machine learning folks would say, overfitting your model, like taking a few imperfect, things that you think are imperfect and kind of changing the whole system so that it will fit those, but it then may miss on a bunch of other things, and it's not clear that there's been a lot of scrutiny to that. And the optics are kind of bad, right? The fact that it followed this unconventional approach, the heavy involvement of Mr. Musk's attorneys in drafting I think you could probably come up with arguments saying, no, this is okay, but it doesn't have the benefit of good optics. Let me just put it that way. On substance, so this first bullet point is something that I think probably people are just going to differ in their opinions about. Like, where should we be setting this balance between controllers and minority stockholders? This clearly is moving it in the direction of controllers, and to some people's lights, that's actually in a value-enhancing way. All right. Other people think that's a terrible idea. I'm a little bit more agnostic about it, other than to say this move is being made without an awful lot of empirical support behind it. It seems to be more of a political move to do this, and maybe empirical support is just really hard to get. But that is a little bit concerning. It's proposing certain legal distinctions, such as the carve out for going privates versus not. That was recently last year considered by the Delaware Supreme Court. Basically said, no, that's not the way it's going to work, and they're super gameable. It's going to be, in fact, those of you who want to be transactional attorneys, if this ends up surviving to the end game, you're going to have some fun as transactional attorneys, and I'll try to give you a sense of what that might be like. There are new constraints on the Delaware Court of Chancery that maybe, at least arguably, could be unconstitutional constraints. All right, I'll say a little bit about that, and then I got some other thing I was going to harp about. Oh yeah, there's a sense, I think this is the thing that may worry me the most, is there's a sense that these proposed reforms try to address a problem, whether you think it's a true problem or an imagined problem, try to address a problem, and the means that it uses to address the problem seem to clip the hair off of Delaware's presumably vaunted advantage, right? Its expert court system, its a lot of its precedents and so forth. So I'll say a little bit about that as well. I did crowdsource the gameability part of this, so this is a LinkedIn post that you can find of mine, and I invite the students and the faculty in the room to submit, but the whole challenge was this statute basically is going to treat going private transactions or squeeze out transactions under the current rules, but everything else is going to be under a more lax rule, which means you don't want to be a squeeze out transaction. So can you draft some kind of self-interested transaction involving a controller that would not be characterized as a squeeze out, but would pretty much replicate the economic implications of a squeeze out? All right, and so I even had a law professor put in a couple of proposals as well. So here are some of them that have come in. A few of them are mine, but a few of them are anonymous former students, and I've got a law professor as well, and I'm happy to collect others. Is this bad? Well, I think from a policy perspective, if something is easily gameable, and then we're just going to create a parlor game of paying lawyers to navigate around it, maybe not so great. I got to tell you though, if I'm a 3L who's going to enter transactional work, I might be licking my chops a little bit here, right? So this might be an opportunity to sort of think about ways to engage in creative forms of transaction engineering, right? Which is it's a pedigree thing, right? You take the laws as they're given, and then you try to figure out how to structure transactions with your client. There's this question of constitutionality. I am not a constitutional law scholar. I mainly stayed awake in constitutional law, and none of it was about state constitutional law, by the way. But I will tell you this, that there is a part of the Delaware Constitution that says the Court of Chancery has all the power vested in it at the time that this Constitution is enacted. And then a later section says the General Assembly can add to that if they want. All right? So there was a case back in 1951 called DuPont versus DuPont, which is like a very Delaware name, by the way, because DuPont is a Delaware company, longest standing big Delaware company. I think this was like a marital spat case. But it basically said, it invalidated a General Assembly amendment that essentially undercut the Court of Equity's equitable powers below what they were in 1792. All right, that's still on the books. It's been cited from time to time. I would expect that there will be some kind of a constitutional challenge, right? Because the precedents are there, and in fact, proposed amendments 144 explicitly say we're not going to allow courts to give equitable relief for stuff that, all right? And so there's going to be kind of an interesting face-off here. Who's going to decide this face-off? I guess it's going to be the Delaware Supreme Court, whose 36 precedents would have been invalidated by the amendment. So that's another delicious little detail, right? We'll see exactly how that plays out. And then finally, here's that dumb chart that I put up earlier, right? I want to amend the chart a little bit, just sort of say, okay, this was sort of the stuff that was beneficial from, that is thought to be quite beneficial about Delaware. How does this particular proposal push? And I think the thing that concerns me, I'm going to edit it here, right? Do a little red line editing of this chart, and I'll just go over the places that are edited. First of all, it's going to replace a fair amount of now existing judicial discretion with much more rigid, pejoratively, maybe even cookie-cutter rules about who's a controller, who's not a controller, and so forth. All right? And if you distrust the judiciary, that's probably what you want to do. But if you got a system that sort of says, no, part of our strength is expert judiciary who we give discretion to, that's kind of an inconsistent move. Second, it's going to overturn a lot of precedent. So if you kind of think about the precedent, the Delaware precedents is like stars in the sky, and you're navigating your ship along the, with these stars. Suddenly, a bunch of them go dark, and your captain isn't able to steer anywhere that they want. There's more risk involved, right? There's just not, that value proposition of predictability is getting whittled away a little bit. Not completely, of course, but a little bit. It's an immutable rule. It's been crammed down. It's not using the traditional processes, and it's essentially visiting a reform that, by my lights, is inconsistent with the contractarian I guess backstory in Delaware, right? Which is also, concerning. And we don't know how capital markets are going to react to this. I think that remains to be seen. There's so much noise going on in capital markets right now. It's going to be really challenging to measure it. We still have this network effect. You guys are still learning Delaware law. Probably will for the next few years. But if this race starts to get more heated, that probably will change as well. I have contemplated doing a little unit on Nevada corporate law, a little subunit on Texas law. For the record, I already own cowboy boots and a bolo tie, so I feel I am credentialed to be. Charlie, I'll lend it to you if you want. All right. Okay, and this is actually this is an overstatement, but because I knew it was going to be coming to the end, I figured I'd give you a little overstatement, right? Delaware law prides itself on the Delaware way, which is essentially the collection, the constellation of those forces that I was talking about earlier. And I guess it's a fear that I have. I don't know for sure whether it's going to take root, but it is a fear that I have. Is the Delaware way is essentially going to get subordinated to a move fast and break things sort of approach. We've definitely seen a lot of this in the federal government over the last month. That may be something that we're going to see a little bit more kind of along all different dimensions. And so if this legislation passes, and this is what I'm going to close on, what should we be doing to kind of think, in a dynamic and adaptive way? Because I think that in some ways is like, it's like, okay, look, it's irritating for someone who's got like already really well honed PowerPoints for my class, but it's also kind of interesting to think about what this is going to look like. All right, so first of all, I guess, is it going to pass or not? I don't know, right? The usual story on this is that if you have proposed corporate law legislation in the Delaware Assembly, a lot of people kind of fall asleep, but they fall asleep with their arm in the air, all right? And it generally has a pretty smooth glide path to passage. This one has some interesting quirks in it, has definitely brought out critics, so it'll be interesting to see whether it destabilizes that kind of historical track record. We hadn't been quite in a position like this. There was a little bit of a kerfuffle with the market practice things last year, but those went through the council, and there was a little bit more of a kind of a standard debate. But this could be kind of evidence that Delaware has become a little bit less predictable. And instead of basically handing the victory laurel to Delaware for winning the race, we might have a new race. Like the race might be on in a weird way, because I think part of the rationale behind these amendments is to maintain the lead of Delaware. But if it does so by essentially chipping away at its comparative advantages, we actually might see a heating up of the race. And whether you think that is good or bad, I'm not going to say I don't care, because I do care. But whether you think it's good or bad, it's a thing that I think we collectively are going to have to sort of think through. And so if this race accelerates because of these amendments, it's going to accelerate quickly. And I think kind of keeping your eyes peeled on how are the new precedents taking shape in Delaware, what are they looking like, how are they taking the language and then trying to adapt it, again with this kind of twice tested type of thing. That's also going to be true for transactional attorneys, right? You guys, the transactional attorneys already have like some fun and games to engage in the squeeze out, non-squeeze out area. And then, is there a reason then to start paying even more attention to what's going on in Nevada? What's going on in Texas? What's going on in North Dakota, California, New York? Maybe New Jersey will get back in the mix after its domination of corporations was taken from it in the early 20th century by Delaware, which pretty much copied its code anyway. All right. So this, I think, it might be scary. I mean, like for a grandpa vibing dinosaur like me, it's like a little bit like, oh geez, I gotta learn all this stuff again. That's probably true for senior partners and established long-standing practitioners. But if you're a young attorney and you basically can dunk on Texas corporate law, you might be the only attorney in your firm who can, or one of two or three. So I think this may actually give rise to some interesting opportunities for entrepreneurial, transactional, and litigation-oriented corporate lawyers. So there's a part of it, and maybe I'm just like a dopey Labrador retriever, always an optimist type of thing, but there is a sense in which this could be we could be in for some interesting days where we have a real race on. There's actual competition that's going on between the states, and we actually kind of get to see whether it's going to ultimately in 2025, 26, 27 be a race to the top or a race to the bottom. If you're interested in this, this is like a self-serving plug, but I knew I could probably sneak in the last 30 seconds. There's a large literature on thinking through kind of how do these corporate law or these regulatory competition scenarios play out. I've got a couple pieces in there. You can take a look at them for no other reason. You can get a good literature review out of them and kind of get a sense of how that may play out, because this literature may start to play a role in general policy debates, law review notes, articles, and so forth. So there's a part of this. I was talking with Dean Rose, who left, but before the session started, that there's a part of me that feels like I'm like a white lab coat wearing oncologist, and a new form of cancer was just discovered. It's like, wow, that's really bad for society, but that's kind of fascinating for my day job, right? And there is an element of the instability that we have right now that, on some level is going to raise questions that have to get answered, and they're probably going to be answered not as much by me, because I'll be like, I don't know, living in a boat in Florida or whatever, but certainly by a lot of you guys. And I know I'm out of time now. Maybe one or two questions from the students, if you guys have them, and then we can adjourn and you can harass me. Yeah.
So as this race potentially tightens up and there's opportunities, do you think like legislators in other prospective states, Texas, Nevada, get a glint in their eyes, see an opportunity to capitalize and really tighten up?
Yeah, it is happening now. So just last week, Nevada, so the question is, are other states going to start saying, hey, Delaware might be vulnerable? It's happening right now. Nevada has basically proposed a constitutional amendment to create a committed form of business law court. Right now they do have business law courts, but other stuff leaks in and it's not quite as committed. Texas obviously has created a brand new set of business law courts. And so I think that other states, if they are savvy, are thinking about not only the complaint that predated these things, but if these things get passed, Delaware looks more like a Model Business Corporations Act state. Its judges don't have as much discretion. We might be able to make a real play to grab some market share. And then the interesting question to me is, what is that going to look like? I have a strong intuition, and some of these things, you'll see how that works. In a lot of these regulatory competition sort of situations, you actually don't get a huge payoff by copying other people. Because when you do that, you put yourself in a maximally competitive situation, right? People, just by charging people more, like a penny more in tax, they'll just go somewhere else. So you kind of want to differentiate yourself, all right? And so my sense is that this thing really gets kickstarted. We're going to see states that really do sort of come in hard and say, here's how we are differentiating. We're the controller-friendly state. We're the minority stockholder-friendly state. We're the CEO who wears green socks-friendly state, right? And we'll get a sense about how that competition is gonna work out. In the long run, it actually could be quite beneficial because companies will be able to self-sort in certain ways. But that also kind of hinges on you sort of thinking that the race to the top idea has more legs than the race to the bottom idea. And in any event, it's going to take a while for precedents to develop and muscle memory to develop. There was a question in the back.
Oh, yeah, I was just going to point out something I thought was interesting with the amendments in the cases that it's going to overturn. One of them that I saw was the Maffei v. Falcon case, which just came out earlier this month with TripAdvisor.
Yeah.
I was wondering if you could touch a little bit more about how it exactly would overturn parts of that case.
Yeah, so some of you guys probably know about this TripAdvisor case. It's a really good case for this kind of a talk because TripAdvisor is a reincorporation case, all right? It is a case where a controlling stockholder basically said, I want to move to Nevada. Minority stockholder said that itself is in fact a conflicted transaction. And then went up to the Delaware Supreme Court and said, you gotta be more precise, stockholders. Just because Nevada is easier on controllers, you haven't said that you got some, like, the controller wants to do some kind of immediate thing that's gonna screw you over, right? It's this kind of inchoate fear that being in Nevada is gonna be worse for minority stockholders. Supreme Court said, no, that's not enough. You've got to demonstrate a material financial conflict, and it's got to be that proximity has to be tighter, right? It can be a future problem, but it's got to be much more closely tied, right? This temporal aspect is important in materiality. And so I think one way that this could actually change the TripAdvisor opinion is, suppose I am, again, controller of TripAdvisor, and I say, yeah, I want to move to Venada, which is a mythical state that has a statute on the books that says I can basically expropriate the stockholders completely a day after I arrive in the state. And I'm just going to tell you that right now, all right? I think under TripAdvisor, that is a conflict of interest, right? It's an immediate move that whose incipiency is no longer in doubt, all right? But it's not a squeeze out, all right? And because it's not a squeeze out, it's probably single layer of cleansing, all right? So there is a sense in which, even though TripAdvisor is understood by a lot of people as being controller friendly, it's not even going as far as the new section 144 would go. Capisce? You disagree, or you think that seems about right?
No, I think that sounds about right.
All right.
Thanks.
So why don't we adjourn to the reception before all the food vanishes, the way that all food vanishes in our school. But please join me in thanking
All right, thanks so much. Really appreciate it.
Thanks for attending.
Oh, yeah? Absolutely.
It's so weird to see you present not in ski pants.
Are you going this year?
I'm not. This is gonna be the first year I'm not using.
You're not going?
No, it's great.
Hey, nice to meet you too. Thanks for your good questions.
It was a super